Oh my gosh, it's really good to see people.
Oh yeah, you can see them.
Oh my gosh, hi. I forget how much I miss our core humans when I haven't seen you in so long.
How's everything going?
Good.
Good.
Hi, Dawn.
Hi.
Hi, Dawn, Chad.
Well, good morning, everybody. I am Paige Spratt with Schwabe, Williamson & Wyatt, and I'm the current president of the Clark County Bar Association. I'm having an abnormally, well, actually it's normal now, but a really bad hair day and everything day. So I'm just have my picture up from 15 years ago. And I want to start off, I want to apologize to those of you who were unable to join us yesterday for Judge Fairgrieve's presentation regarding Superior Court. The original Zoom, the Zoom account that we purchased only maxed out at 100 people. And we were not anticipating having such a great turnout with only 2-day advance notice. So we maxed out quickly. And we have since upgraded our account to allow for 300 people. So hopefully there's plenty of capacity now. It looks like there is. And if you missed Judge Fairgrieve's presentation, you can find it on our website. Today, we have the honor of having Judge Parcher and Judge Osler to talk about COVID-19's impacts to district court and give us a really good update. We're going to be taking questions because we have so many people using the chat feature in Zoom. So all chat messages will be received by our presenting judges. Either Lisa Darko will ask them or she will send them over. We're also working on providing a CLE on Zoom training, which we are planning to provide to our members free of charge, since Superior Court is also heading towards using Zoom, and it's being currently used in district court. So I want to thank our judges for taking the time today, and I'm going to go ahead and turn it over to them.
All right, good morning, everyone.
So, and I guess I'm going to start. So for those of you who don't know me, I'm Judge Kelli Osler. I'm our presiding judge, and Judge Parcher is the acting assistant presiding judge. So we are your presiding judge team for district court. I just want to outline briefly what we want to cover today. I know that Judge Fairgrieve, although I didn't see his presentation yesterday, I did see his PowerPoint, so it sounds like he probably went through some fair detail, the Supreme Court order that we're currently under, as well as our Superior Court administrative order. I just wanted to let folks know that District Court has also done up their own administrative orders, which I believe was sent out with this Zoom invitation, and you can find it on our website by going to the District Court Closures tab, and it will pop up there. So I'm just going to go over briefly what's contained in that order, and you will notice if you look at the order that it is set to expire on June 1st. So there will be another updated order coming out. I imagine once we get some guidance from the Supreme Court and the governor's office on sort of where we're going to be in the next few months. I'm planning on talking to you about what we are currently doing now and what we anticipate we'll be doing at least for the month of June, if not longer. And then Judge Parcher, because we have already started doing these virtual hearings, she's going to kind of give you the nuts and bolts and the do's and don'ts of virtual hearings. And then hopefully at the end, we'll be able to get to some of your guys' questions. So the current order on our website, for the most part, outlines sort of what we've kind of started instituting in the month of May. So as far as infractions, even during our shutdown, we've always been allowing folks to send their infractions in electronically for contested or mitigation. And I believe Commissioner Bartlett has been handling telephonic hearings if you're an attorney that has an infraction. So you just need to contact her department to figure out when those might be. I assume in the near future, they'll probably transition over to virtual on those as well. Anti-harassments, again, we've been hearing those all along. Those can be filed if a person wants to file a petition. It can be filed electronically by mail, or we also have a Dropbox, which is applicable to, you know, pretty much everybody that's filing stuff. And the Dropbox is outside our administration lobby, so You can leave documents there and we'll check it and empty that Dropbox daily. A shout out to Judge Parcher and both Commissioner Bartlett and Commissioner George, because they've been working on hearing the backlog of hearings that were not heard during the kind of shutdown portion of it. So they heard those telephonically, and I heard that they went pretty well, and I think we're pretty much caught up on that, and they're still going to be doing those telephonically and transitioning into virtual. Those hearings will continue as we move forward to be scheduled on Fridays, and we anticipate either having Commissioner Bartlett or another judicial officer to back up if there's too many. I think Judge Parcher will kind of give you an idea of how long these hearings have been taking us, and it's a little bit longer than if you were just to come into court. Civil, and I know I have at least some of you civil folks there. So we've always been accepting those ex parte electronic motions since the middle of March, since we shut down. And we have put on hold for the month of May civil, but I think even the most recent Supreme Court order highly encourages us to be doing those hearings as well. So starting in June, we're going to begin rescheduling the hearings that used to be live, but they'll be held virtual. So you can look at our website, and Judge Parcher will talk about it on how to appear via Zoom. Everything that's on there about the do's and don'ts applies to anybody doing a virtual hearing. And then, I would encourage you also for everybody to just check with your individual department on scheduling, and on your civil week, make sure. I know, for instance, our civil judges are going to back up Commissioner Bartlett on Wednesdays in the month of June because we have a number of contested hearings that have not been heard. So we're going to need more than one judge to hear those hearings. And so if, for instance, one of your judges had their regular civil docket on a Wednesday, please just check with the judge to see what date they'll be holding those. Currently on criminal matters, we've been all along handling our in-custody matters via the video arraignment. And the one thing I guess that shut down changed since the shutdown was, instead of doing DV arraignments in custody live in the afternoon, we've transitioned to having those heard through our video arraignment system as well over at the jail. And that will continue even as we move forward. We're also introducing in the month of May, if you had a case that was previously scheduled, i.e. a defendant knew about it and it is an arraignment or a mandatory, we heard those virtually. Last week, I believe Judge Langsdorff heard her mandatories telephonically. I just heard this week arraignments virtually, and we'll talk about that in a moment. But it worked out well. I mean, we've been hand calling people because we weren't able to send them clear information that this is how your hearing's going to be held in time. And so most people have called in, and today I was really excited. I think I had a 67% appearance rate, which I don't know live if I'm having as many people appear as we did telephonically and virtually. Most judges also currently are working on what I would call their backlog of cases. And I would say most of us would like to start with those cases we know that we can resolve. So if you have a case that's been on hold and you have a change of plea, maybe a diversion confirmation or a deferred prosecution entry, contact your judge and see if you can't get those heard. They'll be setting those hearings up virtually. As far as the fact that we're doing these hearings, we will be sentencing folks like we normally would. And I know there's been, for instance, on a DUI, there's some mandatory jail time. And what are we going to do about that? So we're going to be flexible. We will give report dates. We'll be flexible if we need to extend those report dates or maybe just set over that portion to give them a report date later in the future. If they have an electronic home confinement sentence that they need to serve, now is a perfect time for them to be serving that first. And then maybe moving into their jail time at a later time. Our probation department is currently, they've been doing telephonic check-ins with people on probation and pretrial release. And they're going to transition over to also being able to do virtual check-ins here fairly soonly. So although it's not live court, we're trying to do just about everything that we could do in the past live. We're trying to do it by this virtual means until we get some further direction on moving forward. And then not all judges want to hear everything yet, because we just don't want to have a lot of setovers. We're trying to limit these number of hearings. We're obviously going to have to hear cases at some time in the future moving forward. I'm planning on trying to hear matters, and I might just be, instead of doing setovers, we get in the habit of setting things for trial if we just can't resolve it. Our problem is currently, by the Supreme Court order, we don't know when we're going to be allowed to do those trials yet. So we've been kind of holding off on that. The month of June, changes that you will see: infractions, once again, will still be heard telephonically or virtually and electronically. Anti-harassment orders will still be held telephonically or virtually, and you file those by mail, electronic, or Dropbox. Civil, like I said, we'll start doing virtual hearings in the month of June, and electronic ex parte filings. And criminal, and Judge Parcher is going to show us, we now have a summons that we're getting ready to send out, which we can do for those folks that are scheduled for the month of June. So we have some people scheduled for arraignments, or will be scheduled for arraignments. And as you can see, there's a checkbox that just basically tells them it's going to be a virtual or telephonic hearing. And they're also going to get a handout, which you folks got as part of your handouts today too, but I think she can show that and share it on the screen. I think she's looking for it.
I'm getting there.
Okay. And this will go along with that check-in, but well, as you're talking to your clients, it's kind of imperative you get us email addresses, phone numbers, so we can send out these Zoom invites to everybody. So this tells them exactly how they can log on. It's also, if it isn't yet, it will be on our website. So folks can access it there. You can always refer people to our website. Our website will constantly be changing. So, all right, let's see where I left off. So as far as arraignments, so what we did, we had some arraignments scheduled for May, which were arraignments that we would have heard originally in March. And then we didn't schedule any after March 30th because we just weren't sure how we were going to be moving forward. So now the arraignments that we should have been hearing in April are going to be summonsed in for June. There are some cases that were filed with the court, so the new people will start receiving those summons telling them those arraignments will be held virtually. The prosecutors are also receiving, they've been receiving what we've always called kind of like cold intake, and they've been holding off on filing. So they're slowly going to stagger filing those cases, and those cases that people were getting citations and things like that while we have been on shutdown are going to be starting to be heard in June and there forward for arraignments. The in custody docket will continue as we've always been doing, although I think starting next week we're going to work on handling that via Zoom so that the attorneys can appear remotely. Currently, they've been coming down to the courthouse and talking to their clients with our system, but the idea would be that they'd be able to do it much like we're doing all of our other hearings. We're also going to be introducing mandatory pretrials that have already been set. CAMUS will be hearing those hearings virtually, and the PV docket, we're going to start hearing those matters in the month of June. Again, I encourage you to contact your assigned department. We've all been given expanded scheduling times because we're not doing jury trials, and we know through our order and the Supreme Court order that that's through the month of June. Whether it extends past the month of June, I can't tell you yet, but I anticipate we'll get some guidance here within the next couple of weeks from the Supreme Court. So we're spacing these hearings out because they do take a little bit longer. we're trying to work with folks. If you have a chunk of, say, like 5 defendants that you know that can be resolved, then I'll try to put you on with the assigned prosecutor and just handle them all at once, so that you're, you hopefully aren't having to appear multiple times, at least in front of me, for multiple defendants on different court dates. So in that way, it's kind of a blessing in disguise. I think that scheduling might become a little bit more convenient for the attorneys. Let's see, I'm almost done. My last little segment was, what does the future hold? We have no idea what our new normal is going to be as far as scheduling. I just was on a webinar, kind of a nationwide webinar on what it's going to look like when we are allowed to open our courtroom doors, what's going to be required. A lot of folks are talking about temperature checks, requirement of masks, social distancing, and as anybody that's ever been to district court will know, if social distancing is required for a long time in our future, our courtroom sizes are just not going to be able to accommodate those large hearings that we've had, or large dockets that we've had in the past. So I imagine that there'll be some form of virtual hearings being held for a significant period of time in the future. So we welcome comments and suggestions. I got a really good one today that I hadn't thought about. Thank you, Mr. Pliska. And so we welcome those. And as we work through this, if you're nervous at all about trying out the Zoom hearings and you haven't done one, you're free to contact a JA, a judicial assistant, and they can just send you an e-bite, and you can kind of mute yourself, much like you're doing now, but be able to observe those proceedings. We're also hoping very shortly that we're going to be live streaming these hearings as they're going on YouTube, and people will be able to access them through our website. And then those hearings will, after the court hearing, won't be available after that unless you order a court copy from the court. So, all right, now for the fun part would be Judge Parcher.
Yeah, way to set me up for failure. I hope it's fun. So I just want to talk about the mechanics of scheduling in a virtual meeting or hearing, and kind of the expectations of the court. So, I mean, the general mechanics, as Judge Osler said, we're really trying to schedule as much as we can right now with each department. We've all created room in our schedules to do that, to really work through the backlog of the cases that were canceled since March 16th. And then going forward, so right now when you contact the department JA, you'll need to be able to provide the defendant name and good contact information for them. We cannot send invites to telephone numbers, and so email is preferred. It's the easiest way for the defendant to get on, and it's really the easiest way for them to participate by video. Attorneys can also forward that information to their client, and they should be able to click on that link. I do know that we had one attorney who cut and pasted, and then the link didn't work, but at least the information was in there. So just know that it may be that if that link's not working, tell your client to, be patient and manually put in the meeting and the ID. That should all be in that invitation as well. But email for participants is just the easiest way for us to send out that invite to everyone that we can. We also would expect to, when you're scheduling those hearings, to let the JA know what the expected hearing resolution is. So for example, if it's going to be a change of plea, trial setting, we're trying to prioritize at this time as many cases that can be cited on for full resolution, change of pleas, diversion, those sorts of things we're trying to do now. If we have to prioritize, it'd be those first, and then trial settings, and then other sort of reviews. If we get really busy, then we'd have to go kind of oldest to newest. But right now, we all have plenty of time to keep scheduling hearings. We're not backed up. We got lots of time to start working on this stuff. And then, so once you've contacted the JA with that information, they're going to calendar the hearing and let you know about that date. They will send a Zoom invite to counsel and to any of the litigants by email when possible. And that might be, right before the hearing. It might be a few days prior. It kind of depends on the judicial assistant waiting for confirmation and additional information from their clients. So just be patient, but it will get to you prior to that hearing day. And the departments, I think we're all kind of trying to keep it around 5 to a half an hour increments. So for example, instead of scheduling everything for 8:30, we would do a chunk at 8:30, a chunk at 9, a chunk at 9:30, so that hopefully, especially for litigants when they're, you know, calling in, for example, we would resolve their case within that half-hour chunk, so they're not sitting on their phone. We worry about, you know, batteries draining, loss of connectivity, those sorts of things. So that's how it'll kind of look going forward, is that we'll have staggered start times. On the hearing day, just make sure that you join in a few minutes early. I will just let people know one of the things that have come up. For example, if we do an 8:30 and 9 and we get behind on our 8:30, we can't open up that 9 o'clock docket until we finish the 8:30. So if it says it hasn't started yet, just be patient, keep trying back. It just means that for whatever reason we got held up and we're still resolving some cases from that previous time setting. When people join, how it looks is everyone goes directly into a waiting room, and there'll be a message there that maybe several minutes before your case is called. So just to be patient, which is, I'm not patient, so I appreciate that. We had some discussion over the several minutes because someone said it'll be shortly, and I said, oh no, that's, you know, that'll drive people crazy. But please be patient. The judge will then call the participants in as they're ready to hear their case. If the defendant or other litigant cannot appear by video and the attorney wasn't able to get them the Zoom invite information so that they could join by phone, we can call them directly when we're already within our Zoom hearing. And we've been doing that a lot, and actually it works really well. We still prefer the defendant to appear by video, but if they cannot, it's also really easy to call them once we're in there. We get the attorney and prosecutor in there and then make the phone call. Since I'm doing the domestic violence docket, we've also been adding in advocates. We can have, you know, victims appear, so we can add in who's ever necessary for that hearing. We do have breakout rooms, and a lot of you have already seen an example of that, but essentially the court has the ability to send a couple people into a confidential area where they can talk. So if an attorney needs to talk to a defendant, or maybe even on the civil docket, if an attorney needs to talk to someone who's pro se about payment plan or possible resolution, the court can put those folks into a breakout room. One of the things to keep in mind why we're requesting that people appear by videos, there's more functionality. You can choose to go back into a courtroom when you're doing it on video. When you're by telephone, you cannot return. So it has to be the court basically closing that room and bringing folks back. And if you ever want to practice with a friend on that, or practice with the court, all of us have just been kind of joining in and playing around with these functions, but the breakout rooms have proved to work pretty well. For in custody folks, the jail, we're taking the jail rooms into the hearing as well, and we can do the same thing for those of you who haven't already had a chance to do that. We can put the attorney with the defendant into a separate breakout room to talk before coming back into the court. And again, just with the nature of the court having to bring the jail booth back, there's some limitations, but it's been working pretty smoothly. If there is paperwork relevant to the hearing, so example, a change of plea, deferred prosecution, diversion, maybe something in a civil matter where the litigant needs to sign something, the expectation is that paperwork would be reviewed with the client before the hearing date. They must have a copy of that in front of them. You know, so when the court's going through that paperwork, they know what it is that the court's referring to. It needs to be signed by the attorney as an officer of the court. We're not requiring signatures from defendants at this time. You know, always, if you have the ability to have electronic, you know, DocuSign with your clients or with other litigants, that's great. But we just know, especially with some of our criminal defendants, that's a little more difficult. But we do expect the attorney to sign it. It needs to be forwarded in criminal cases to the prosecutor, and civil cases to the other side ahead of that hearing. And then you email that to the judicial assistant. And it needs, you know, we're asking for day before, but at least in time for the judicial assistant to print that out for the judge. For example, in a criminal case, I would get the plea form, it has the factual basis, it has the prosecutor's signature, the defense attorney's signature. I review it with the defendant, and then I'm actually signing that, and then that becomes, you know, the part of the file. We can also do kind of duplicate originals. So if we have one that's signed by attorney, one that's signed by defendant, we can attach those all together too, and as part of the court file. And again, so we're not requiring signatures. Things can be signed on behalf of the client by the attorney. The court will have defendants essentially acknowledge the terms of any court order, the set over, and that they're accepting service of that court document either by mail or email. So we will make that acknowledgement. If you feel like, you know, you want the court to do something, if you feel like it hasn't been acknowledged or something, you know, please let us know. But the court will then send documents to the defendant. We will have essentially a generic email. So like in criminal cases, I might ask a defendant, where are you agreeing to accept these service of these court documents? Okay, I'd like it by email. We get that email on the record, and then the court will send it out, and it'll be kind of a do not respond to this email, it'll be generic. We can't really put our judicial assistants in the position of sending stuff, because then they end up kind of inviting conversation with folks. But if, you know, if there's retained counsel too that's would rather just get it directly to their client, that's fine. Again, it's just something that we would put on the record. So there's no question that they knew what the terms of the order was and where they were agreeing to accept that. One of the things I just want to point out, the record, when we do it by Zoom, the way it works is it's going directly through our JAB system, which is our audio recording system for our court record. So it's an excellent recording of the proceeding. It's far superior to when we're doing telephonic hearings and it's essentially a telephone into a microphone. It is going directly in, so we've been really happy with the quality of the record. So now we're gonna get a little funny because we're gonna talk about expectations of appearing virtually. You'd be surprised at some of the things that we saw today. So again, everyone's expected to appear by video unless they're lacking the necessary equipment. It makes for a better record. There's better functionality within Zoom. You know, there's no, it kind of just decreases any concerns about identity of the person who's participating. And frankly, the court really wants this to look as much like a real court proceeding as possible. I think it's important to the seriousness of the allegations against folks, that they be treated with respect, that it be a respectful setting and look as much like court, so we can really just convey to people that we are taking this seriously. However, you know, I know that we don't always take, you know, ourselves seriously, but just know that you are on the record. And so to that end, you know, really advise clients also to familiarize themselves. Again, refer to them to our district court website on virtual hearings, to that remote hearing handout. Advise them to dress accordingly, remove background noise, those sorts of things. Also, when you come in on Zoom by video, when you do it the first time, it's going to ask you what name you want to appear. Don't do something funny, because that's what's going to show on the court record. Don't send me veiled messages through however you decide to name yourself. Make sure that you have a good, accurate name. And then also picture that for court purposes, you know, just a first name doesn't work either. We have a waiting room full of folks, so if we have full names, it's just going to make it go a lot more quickly, pulling people in and out of the actual courtroom setting. So I do just want to remind you that we expect everyone at this point to abide by the local court rules when it comes to how you dress. I'll just remind you that our definition is current, generally prevailing and accepted business attire, including ties and jackets. So, you know, please just keep that in mind. Our local court rule actually requires attorneys to advise their clients how to address as well. You know, we'd also ask to, I know that folks are working from home and sometimes it's just easy to kind of be in your regular setting, but there really shouldn't be food or drink. Folks should not be eating or drinking during court proceedings, just like you wouldn't do. We just really want to remind folks that the expectation is that we are treating this like, you know, any other sort of hearing. Some of the things that we've just seen to keep in consideration, and this is with the caveat that at the end of the record, on multiple occasions, I've asked people to share their animals with me because I do love animals, but just make sure during the hearing and that you're advising clients too that having pets in the room could be distracting. I was going to take a picture with my black lab, except she just sleeps on my feet and is really not distracting. However, my mean chicken might act differently if I was trying to do court from out in my barn. And then just be really aware too of the surroundings behind you. I think we've all seen some of the funny things about, you know, spouses walking in the background. I understand it might feel like an invasion of privacy to have hearings from your home. Hang up a sheet. We don't care if it's pretty as long as it's not distracting and it's appropriate, because there really are some backgrounds that could be distracting from an office perspective. And again, we're trying to really take court seriously, make sure that defendants feel respected, and that, you know, everything appears as if it's in an actual courtroom setting.
Okay, can I just add, there's a caveat. That is my college-age son's bedroom, and those are hanging on his wall, but that is not something I would normally have in my house.
It's not your bedroom, Judge.
Not my bedroom. I just wanted to add that as a caveat.
So and then that's about what I have on the mechanics and the expectations of the court. You know, again, how we're returning to in-person, we really don't know. We do have everything measured out in district court. We have stickers to put on the floor when we reopen our lobby. We don't know when that's going to be yet. We're anticipating putting, you know, X's on the seats. But for example, in G2, which is our biggest courtroom, in order to social distance, we can only have 20 people in there and 4 attorneys. I mean, that's tiny compared to what we usually have. And open court jurisprudence, we have to assume that there's going to be some folks that come to watch, that we may have, you know, victims in courtrooms, those sorts of things. So it's not even like we can schedule 20 defendants at one time. So it's just going forward, I think we're going to be using virtual a lot. And I think that there might be some real benefits in the long run too, when we have, you know, frankly, people who can't participate live for whatever reason, mental health issues or just being ill, or, you know, ways that we can really kind of use this to our advantage now that we'll have it all set up. I did want to talk briefly, you know, one of the things with the anti-harassments that we're running into now is we have not yet been trained. We have the capability. We're working on what's going to be called a Dropbox for evidence. So as we go through with hearings in different places where evidence needs to be shared, including potentially trials or bench trials going forward, basically parties will put their kind of marked exhibits into this Dropbox, and then they would be able to pull those out as necessary. I do not yet know how to use it. I will, as soon as it's available, that's kind of our next level, so that we can start going through with more evidentiary hearings, suppression hearings, potentially bench trials, those sorts of things, and using that evidence. Right now for anti-harassment hearings, we're just asking that the parties email the documents to the court and the court tries to get them to the other side. But if there's multiple parties or people don't have good email, that's difficult. So there's places where we've had to set hearings over, or where there's just the volume of evidence that we might just have to keep kicking it until we can actually have them appear in person and special set it to where we can social distance. So just know that we do have kind of that in the works as well, that Dropbox option for evidence. And, you know, we haven't scheduled a bench trial yet, but we'll keep you updated as to any policies around the court. And certainly the court's gonna, you know, take and consider any briefing around confrontation issues and those sorts of things, and availability of witnesses around that. So
I just have a couple of things to kind of feed off of there. Just in the renaming, in case you don't know, if you just put your cursor over your picture, it says mute where you can mute yourself, but there's also 3 dots. And if you click on that, there'll be an option to rename yourself. So, and you can just click on that. And so like Judge Parcher was saying, first and last names are helpful. And then the other thing is you can change your virtual background. Judge Parcher and I are not currently sitting in court. And I've not seen the screen from this view because I've been running the hearings, but I'm looking at my bottom left-hand corner of my computer screen, there's a stop video and there's a little arrow up. And if you click on that arrow, they have virtual backgrounds. For instance, there's just some preset ones.
Except, I think Judge Osler, I think we've disabled that for participants.
Oh, so you can't see that. But anyway, you can always Google it. Oh, I got to fix mine now.
See, and that's why. You don't really want.
I shouldn't have done that now. I don't know.
The temptation to change backgrounds is just, we don't need defendants appearing from the,
Yeah.
the.
I get that, but I just think for attorneys, like I was talking to someone that didn't want people to see her, what was in her house necessarily.
Well, and I know that it might be nice for folks to use virtual backgrounds, but because we can't just kind of shut it down to certain participants and not others, just in order to make sure that things are kind of.
For attorneys, yeah.
Yeah, we've disabled that, I believe, so.
Oh, okay. And then it's really important. We've been trying to do it in court, but it's really important that you guys get updated emails, addresses, and phone numbers for folks, because that's how we're sending out these notices, and we might have to share back and forth with those. I mean, right now I'm asking for people's information on the record, which isn't necessarily ideal if I can get it from the attorneys, but any emails we can get from anybody, that just helps us to send out our invitations to them in the future.
I think we're ready to open it up to questions at this time, and so folks can can chat that to Lisa if they want. See, it's a good way to practice using the chat function.
And I've learned that you can, well, I won't tell you that, but you can chat privately with one another. I wouldn't share that with your clients necessarily, but you can chat with everybody where everybody can see it. And I've had to do that. We had some technical issues earlier this week and people couldn't hear me. So keep in mind that you might see something pop up on chat. The other thing about appearing via video that I've discovered is if you're an attorney and I need to put you in a breakout room with your client, if you're in a breakout room and you're video, you can get out of the breakout room yourself. If you are on the phone or you are in a jail booth, you cannot get out of that breakout room until the court lets you out. And if we have multiple people in breakout rooms, if I'm letting them out, I have to let everybody out. Also, we've been able to use the interpreters via video, which has been very helpful. So I've been able to put the interpreter, the defense attorney, and the defendant in their own breakout room. And they were able to have a private conversation. And then when they were ready to come back, you know, they invited themselves back in. And if there were any defendants on the telephone, then I could pull them back out.
So we do have a couple questions as well. No, Judge Veljacek, I'm not allowing a Hogwarts background unless that's actually visible in your home, which it might be, I don't know. Another question, judges are opening up schedules with dockets. Will there be a schedule for bench trial days? No, that's just going to be special sets for district courts. So you just have to ask that judicial department. One of the things the court's just trying to be cognizant of is the logistics of that. So giving parties kind of an opportunity to be heard on whether or not it's appropriate to even have a bench trial at this time, depending on where witnesses are and if there's any objections to witnesses appearing by video. If witnesses are comfortable doing that, have the ability to do that. So I just think there's more logistics. So, and then will the court be citing in any defendants? Oh, so that's a good question. So kind of big picture. So right now for May, at least the way I'm doing it, if somebody actually signed a promise to appear for a May docket, we're just holding that docket. They're staying scheduled. All of my extra days and dockets that I have are just by attorney request. And that's really what most of us are trying to do now. Let us know if you have something to clear out. At some point going into June, whether it's kind of mid-June, and it's going to depend on department, and we're kind of working on that scheduling piece, we are anticipating in the next few weeks that we're going to start doing that we're going to start sending notices of hearing to defendants with that virtual language and start doing regular virtual dockets. We will certainly keep folks updated on that. Each department will probably reach out to some of their assigned prosecutors and attorneys. Certainly if you're a civil attorney and you want to cite it on due, but we will be sending out notices to kind of start actually scheduling things in June that haven't already been resolved at the request of attorneys. That's why we're really asking people to try in the next few weeks to get as much on as possible. So, you know, it's just that many, you know, fewer cases that we're having to send out citations for. I hope that answers the question. So it's coming up pretty soon that we're going to start scheduling regular dockets. At that point too, it's required that you appear virtually. I know that we've had that question. I'll just wait till I can appear in person. If you get a summons or a citation, you know, notice of hearing from the court, you're expected to appear virtually for that hearing. We're not going to just keep bumping it because we just don't know when we're going to be able to do in person. And then someone asked, is the county still filing demand for jury trials? I don't know. I'm in the DV unit, so I haven't seen that. And we just resumed doing arraignments. I don't know, Judge Osler, have you seen if the county's doing that, or maybe someone needs to reach out to the county?
I don't know if I noticed that at all this week, that they were filing those, but yeah, the Supreme Court order currently says, and our order reflects that, is July 6th is when we can start. We can't resuming jury trials until after July 6th, but yet they've told speedy trial time until July 1st. I do know that Judge Collier is on kind of a statewide committee where they are talking about juries. I anticipate that's going to get bumped out a little bit farther, but they're talking about ideas on how they're going to be able to use juries in the future, and they're working with the health departments because bringing in juries creates another host of problems with social distancing issues and things like that, and people that are a vulnerable population. So stay tuned for that and keep looking at the Supreme Court orders and our orders as we update them. But
okay, and then I had another question. Should we provide the defendant's phone number and or email and citation, or to the JA? Just provide it to the JA. We don't necessarily expect folks to have their information a public file. Our system where we put their information into it, granted, I guess if we're asking for it on the record, someone could read the record and get it as well, but it can just go to the JA. At this point, we're not really requiring the attorneys to file citations to get it on a docket because we're just trying to kind of get them on. And you might not know when you're going to be scheduled because we don't really have these regular dockets set up. It's more kind of the judicial assistant's going to control the flow because we're kind of doing those short, distinct areas.
And one thing I don't know if we mentioned, on our website currently are a list of forms that you folks can utilize. So you can get the change of plea form off of there, the deferred prosecution petition. We're working on, or the prosecutor I think is going to work on getting some of that diversion paperwork so you'll have access to it while you're trying to prepare for these hearings.
And yes, attorneys and defendants will get notice of summons and citations for the cases that were canceled for no in-person hearings. So we'll make sure that if there is an attorney of record, the attorney gets that as well. That is a great question on the SM. So someone asked on infractions, how do you check SMD certifications? Because they emailed and our employee was working remotely. I'm gonna bring that up with our administrator. My first reaction is you should be able to get an email of the certification, but we'll have to discuss that. And
Commissioner Bartlett's already sent that out to admin via email.
Oh, she has.
Same question, yeah.
Oh, okay. So Commissioner Bartlett's working on that. And so we'll have something in place because that should be, I think, something that the court should be able to email out if we're expecting folks to appear virtually. So, and then I had a question. Most of my clients so far are much more responsive to appearing telephonically. They're due to technical access or competency or appearing while working. Will this continue to be acceptable for defendant appearances for the foreseeable future? Yes, I mean, the preference, again, just because of the functionality and the better record, is that they appear by video, but we're certainly want to allow people to be heard telephonically as well. So just encourage them. It's not that hard. I mean, I essentially may as well have a flip phone. I'm so technologically deficient, and I managed to share some embarrassing photos on this platform today. So just keep encouraging folks, just let them know that it really does, it just works better for the court environment if they can appear by video.
No more questions yet, Judge.
All right. Judge Osler, anything else you can think of that?
No, we appreciate you guys being patient. I know one day this week on Wednesday, we were having all sorts of technical difficulties, and our gals that helped us get this up and running. I mean, literally, we tried out different platforms. We tried WebEx, we tried Microsoft Teams. It wasn't really just going to work with our court recording system before we landed on Zoom, and then it was literally like Zoom. Once we decided that platform, to getting it up and running was a matter of probably less than 2 weeks or a week, and they had to train people. And now they're having to come to court and hold our hands when we have technical difficulties. So we do appreciate your guys being patient in that regard, because we're working through it, and we'll get better as we go along.
So thank you so much, Judge Osler and Judge Parcher. This has been really great. I was on a WebEx hearing this morning, and Zoom is immensely better. So we're really excited about implementing it. And I just want to thank everyone for attending. And please look out for future content. We're working on those free CLEs for the Zoom training. And so thanks again, and enjoy your Friday.
All right, thank you, everyone.
Thank you, guys.